to meeting number 87 of the House of Commons Standing Committee on Indigenous and Northern Affairs. We recognize that we meet on unceded territory of the Algonquin and Anishinaabe peoples. Pursuant to the House Order of Reference adopted on June 21st, 2023, and pursuant to the motion adopted by the committee on Thursday, October 26, 2023, the committee is meeting to proceed with clause by clause of Bill C-53, an act respecting the recognition of certain Métis governments in Alberta, Ontario, and Saskatchewan. We're taking place in hybrid format today. Only members are online. You know the drill, so I'm not going to spend a lot of time on that. For those in the room, now that we've started, no photos are allowed and no screenshots are allowed. I'd like to welcome back our officials. And so I have Martin Ryer, Senior Assistant Deputy Minister, Treaties and Aboriginal Government. Welcome. Michael Shintz, there you are. Federal Negotiations Manager, Negotiations Central, Treaties and Aboriginal Government. Blake McLaughlin, Director General, Negotiations Central, Treaties and Aboriginal Government. And finally, from the Department of Justice, Julia Redmond, Legal Counsel. So welcome to our officials. Colleagues, before we get started into the clause by clause, I have and I'd like to welcome Mr. Eric to the, I don't think we have any other Ms. Atwin. Well, Jenica's here for the duration of this one, so good to see you. So, yeah, with that, clause by clause. So I'm going to go through a bit of a script here so we know what we're up against. So to begin, I'd like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the clause by clause consideration of Bill C-53. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I'll call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it who may explain it. The amendment will then be open for debate. When no further members wish to intervene, and I have double clerks here today to help keep speaking or lists, when no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill and in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. And so that's an important consideration. We are allowed to take amendments from the floor, but they need to be in writing to the clerk. The chair will go slowly to allow members to follow the proceedings properly. Amendments have been given an alphanumeric number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will consider and vote on the short title, and the bill itself. If amendments are adopted, in order to reprint the bill may be required so that the House has a proper copy for use at report stage. Finally, the committee will have to order the chair to report the bill to the House. That report contains only the text of adopted amendments as well as an indication of any deleted clauses. So with that as the instructions for today, we're going to move right into the agenda. And I have a couple of comments here to give you before we get down to business. So, pursuant to Standing Order 75-1, consideration of Clause 1, the short title, and of the preamble are postponed. We will call Clause 2. Now, since there are a couple of amendments to Clause 2, the interpretation clause, I suggest that we postpone the study of Clause 2 until the end. This will allow us to first consider and make a decision on amendments that could have an impact on the definitions. As a reminder, House of Commons Procedure and Practice 3rd edition states on page 773 that the interpretation clause of a bill is not the place to propose a substantive amendment to a bill unless other amendments have been adopted that would warrant amendments to the interpretation clause. Therefore, Clause 2 will be considered after the schedule. So if anybody has anything related to Clause 2, hold that until we get to near the very end. I have it in my notes. I will be bringing us back to that. Is there agreement that we skip clause, or that we, skipped clause, new Clause 2.1? Arnold?
Not so much on this, just before we get into the clause by clause, I was just wondering if we can get some clarification around our supplements motion that we put on and the minister appearing for that. Do we have any word that the minister is coming, and do we have it scheduled at all? I expected before we got to this meeting that we would be hearing something, but I didn't hear anything. So. Okay,
yeah. So the invitation to the ministers, because there were 3 that were in the motion, have been invited. We have not received a response back at this point. They've indicated they will try to get us availability by tomorrow. We were told that this week was out of question, and so we are aiming for either Tuesday or Thursday of next week. And so that's what we've given them, and that's what I'm hoping to be able to announce as soon as we can confirm the 3 ministers.
Okay. Hopefully Tuesday.
Okay, so now we're going to go to new Clause 2.1, and okay, so this is related. Okay. So CPC 1.1, does the member want to move their amendment?
That's you, Gerson?
No, I was trying to find my list of...
1.1?
Because he just said to skip the...
First,
He said that 1.1 this one.
1.1? But you just said we were skipping clause 2.
We're skipping Clause 2 at the time, but we have new Clause 2.1, which is Amendment CPC 1.1.
Okay, but that's also part of clause 2 as well, I think, right? It's a new clause. Okay. Okay.
Maybe it's best we deal with the other 2 before we get to that, so why don't we start with 1.2?
1.2. Yeah, okay. Because we're dealing in the definitions here, right? Or not? Oh, you're just...
I'm suggesting that you go to...
You still have those.
Yeah, all right.
Yeah, so this is Mr. Vierson's 1.1. Have you found it, Mr. Vierson?
I have it, yeah.
Okay, so I'll ask if you want to move it, and if you do, I'll give you a brief opportunity to speak to it as well.
All right. Well, thank you, Mr. Chair. I do want to move this motion to add a new clause into the bill here. This comes from a number of folks, Métis folks that showed up at our committee, and were concerned around their communities being represented by the Alberta, or the National Métis Association of Alberta, and that their rights to be represented by their own community may be reduced, and so they asked for to ensure that they could pursue their self-government separately than from the Alberta Métis Nation of Alberta, and so they asked for this. I wrote into the drafters. I didn't necessarily expect it to be worded quite like this, abrogation or derogation clause, but I know that Jaime mentioned this as well several times, so that this would allow for folks like the Métis of Cadott or the Métis of Fort Mackay to pursue their own self-government and agreements with the federal government in light of that. So that's what this motion is hopefully doing. I would maybe, Mr. Chair, just ask our officials if they have any opinions on this as well, if this amendment would indeed achieve that, that the Métis folks from like the Cadott Métis or the Fort McKay Métis, if this would allow them to pursue self-government separate from the M&A.
Well, I understand the CERNA position to be effectively that they already have that option regardless of whether this clause is in here. So this doesn't change the reality of the statute or the bill as it is already. They still have that option.
And so this would allow for greater clarity for those folks that were concerned about that.
It doesn't change the reality of the bill, which is that that option is available to those other Métis groups, whether or not this is included.
Okay. So yeah, so that's my amendment moved, and I hope to get support from other groups here. Thank you.
Okay, on my speaking list, I have Jaime first. I'm looking to see if anybody else online or in person has their hand up. Okay, Michael, second.
I think it's important that we do figure out how to ensure that the Métis settlements of Alberta are properly reflected and their concerns in this. We feel there has been some discussion, and we feel that the better time to do that is in NDP 4.2, where they're talking about, for greater certainty, nothing in this act to be construed from abrogating or derogating from the rights to self-determination of Métis collectives that are not represented by Métis governments set out in column 1 of the schedule, including the inherent right of self-government recognized and affirmed by Section 35 of the Constitution 1982. We have had some conversations with stakeholders as well as with the NDP, and we feel that that could be greater clarified with the paragraph amendment. For greater certainty, nothing in this act is to be construed as abrogating or derogating from the right to self-determination of a Métis collectivity that has not authorized a Métis government set out in column 1 of the schedule to the act on behalf, including with respect to the inherent rights of self-government recognized and affirmed by Section 35 of the Constitution Act. That's a long way of saying we would rather see it in NDP 4.2, that change, and that's why we will be voting against.
I have Michael and then Jamie.
Mr. Chairman, I thought we had a fairly good discussion on it with the Alberta Métis communities when they raised this issue, and we also had it brought up when the minister appeared before us, and he was quite clear that this agreement, this treaty, would not be the sole agreement for that area, for the Alberta, and I believe our officials also clarified that. So I'm not sure why we need to go to this extent when it's been clear all along that this agreement is not the sole agreement for any jurisdiction. And that includes Alberta. The door is still open for the Métis settlements to move forward. And the arguments that they used was that their own agreements, their own claims were not moving fast enough. And that's where we should maybe make some recommendations to support them in that fashion.
Okay, thank you. Next I have Jamie and then Marilyn.
Maybe a question through you to the departmental officials here. One of the one of the comments or concerns that we heard during testimony was specifically around land that some chiefs in Northern Ontario thought that could be challenged either in court or through negotiations or forced negotiations. Their words, not mine. Does this NDP motion 4.2 address some of those concerns that the chiefs brought forward in testimony?
I mean, the position is the same on both, essentially, that neither changes the legal effect of the bill, that those rights are unaffected regardless of whether CBC 1.1 or NDP sorry, I don't have the number off the top of my head, the similar provision from the NDP, regardless of whether those are included.
So I guess then, can I keep going? Or? Yep. Okay. So the, I didn't know if where the name was going to go. So I guess the next question would be, if this bill passes and then the treaty process starts, and that I think was more of a concern from the Ontario Chiefs was, what comes next? What does the treaty mean? What happens? Which does, from my knowledge, trigger the duty to consult at that point. Okay. Now, once that is triggered and that starts, do you anticipate, with or without this clause here, land potentially being on the negotiating table, as was claimed by some of the chiefs in the committee earlier?
So I think, can you ask the question again? I missed a part because
Yeah, that was a long question. I'll try to remember it. So, okay. So in testimony, we have some Ontario chiefs, specifically in Northern Ontario, concerned that if this bill passed, the treaty process starts, and we're just talking about particularly Ontario at this point, it would trigger that treaty process. In that treaty process, the chiefs from Northern Ontario are alleging that MNO has laid claim to land that was already either in treaty or subject to a land claim with First Nation negotiations. Would that affect, would the First Nations then have to challenge the MNO in court? Would there be negotiations on whether that land is up for grabs? And if yes, depending on this very long question that probably should be broken up into many segments, would this clause help?
Maybe I'll answer. The relationship with our Indigenous partners in general is an ongoing relationship, and the treaties that we enter into are living documents. So we cannot, determine in advance what will be negotiated in the future. What we know at the moment, based on discussion with our partners, is that the next step is to negotiate a treaty on core governance that is on the basis of the agreements that have been entered into and that are available to review now. That is what we know. There is no intention at the moment to negotiate more than that, but the relationship will continue to evolve. If and when there is jurisdiction contemplated on land for these treaties, there would be a consultation phase that will allow Indigenous partners that might be affected to provide comments and be accommodated as needed under the obligation of the Crown for the duty to consult and accommodate.
Can I just add one point?
Yep.
Oh, sorry. I think part of the question was whether or not, after this legislation comes into force or as a result of the core governance treaties that we'll be negotiating as a next step, whether or not that would change in any way the requirement of First Nations, which they gave testimony that they've had to do some amount of consulting with Métis governments already. The status quo as it exists before this legislation and after this legislation would not change in that respect.
Can you repeat that one more time, please? Sorry.
Yeah, so First Nations, as part of the testimony that was given to this committee, have made the point that they are having to consult. I think the Chiefs of Ontario made this point about the MNO, that they're having to consult regarding land selections. And so I wanted to make the point, because I had thought it was a part of your question, MP Schmale, that the status quo in that respect will not change after this legislation, nor would it change on the basis of the self-government treaties that we intend to be negotiating consistent with the 2023 agreements.
Thank you. And one thing that was just brought up in your comments here, and I just wanted to clarify, were you referring potentially to C-53 as a living document? Sorry, I might have caught that. My sound's going in and out.
No, actually, I referred to the treaties that
Okay, the
will
treaty.
be entered into.
Okay, maybe I'll let Ms. Gill go, and I'll probably come back with more questions.
Okay, Madame Gill, we'll go to you, and then I have Mr. Viersen and yeah.
Merci.
Thank you, Mr. Chairman. And I'd like to ask a question of our witnesses and come back to Mr. Redmond. I think you said that for CPC 1.1 that it's a bit as if it's redundant. So you said you'd offer a clarification and that it should already be in the bill. And I imagine it's the same thing for NDP 4.2. So just to check on that, both of these amendments are intended to provide clarifications, but from what you said about this, it wouldn't bring anything additional to the bill. So I understand that we want to help people with their fears about this, but that the adoption of the amendments wouldn't change the substance of the bill in any way. So did I correctly understand that?
Yes, you understood my point correctly. There are, among the amendments before the committee, certain ones which concern a more universal non-derogation clause, and others which appear to be more specific. There is, as I'm sure you're already aware, a legislative initiative dealing with a universal non-derogation clause, that's Bill S13, that would apply to all federal statutes. This would be included within that, of course. So including a non-derogation clause in this bill is not strictly necessary, assuming S13 becomes law, because it would already be covered by that. A broader non-derogation clause would cover everything that CPC 1.1 and NDP 4.2 are trying to cover. Those are a narrower statement of the same idea, which is not to abrogate or derogate from the rights of other Indigenous peoples.
Okay, Madame Gill, you're good?
Oui, merci.
Okay.
Yes, thank you.
Next I have Mr. Viersen and then Ms. Edlund.
The witnesses, when they were here, they were concerned that I guess what this bill is trying to do is in the Constitution, there's the word Métis, and we're trying to define, I guess, who is that? Right? And so that's who is that rights-bearing people? And that was what there was a bunch of concern around, is who gets to decide that? And there was concerns around, does one community get to decide that or the other? And that's what my amendment is trying to get at, is it's not just the MNA in Alberta that gets to decide who's Métis, essentially. That's what my amendment is trying to achieve. Is that not correct?
Do you want to answer?
So I understand the center position to be that, those Métis groups you referred to in Alberta are already unaffected by this bill. The status quo is that those other Métis groups are welcome to pursue their own path to self-determination, and this provision is not required to make that true.
But the direct quote that I remember was that they said, we don't want to have competing Métis identity. So that's why I put forward this. That was the quote that I used to say when I was trying to draft this, was saying, hey, we don't want this bill to create a competing Métis identity. Does that make sense?
I understand what you're saying, but I have nothing further to add unless anyone else does.
Okay. Yeah, I guess that's just some of the logic behind building this my amendment, which is around Métis identity, and this would the abrogation or derogation. I think the drafters like that terminology, but that's what we're trying to get to.
Okay, and thank you. Next, Ms. Edlund, the floor is yours.
Thank you. So you're saying that my 4.2 amendment is basically a duplication of something else that already exists in C53? Where can we find that specific clause that says that it's a duplication of it?
What I'm referring to is some of the other amendments that have been tabled. So, for example, NDP2, which you've also put forward as a broader non-derogation clause, would effectively cover the same scope as NDP 4.2.
So if I didn't add neither of my amendments, then those non-derogation clauses would have been in this bill.
I am saying that given ongoing work on another legislative initiative with S13,
Will pass.
I understand.
Yeah.
The intention there is that the Interpretation Act will be amended to include a non-derogation clause that will apply to all federal statutes. The goal of that being to harmonize those non-derogation clauses to ensure that there's consistency and that they're interpreted in a predictable way.
Okay.
So I appreciate that there's a difference in the interim until that bill becomes law.
So I need to understand this based on a future scenario. So I'm going to ask you to pretend that you're a lawyer in the future that has to interpret C53 as if we passed both of the NDP amendments. What would be the effect of the interpretation based on what those realities are and not based on what the intent of the past is? Because right now, I understand that intent is one thing, but we know that in law, intent doesn't always result in what the interpretation of it will be. So I don't want to base our decisions today on what the intent is, but what the possible legal interpretation could result in at a later time.
If I understand correctly, you're asking the difference between the two non-derogation clauses and whether that affects the interpretation. And I mean, obviously, while it's not for me to provide legal advice to the committee, I can say that I note that NDP 4.2 is more specific to Métis collectivities. It is possible that that could impact interpretation, but it, again, is not for me to advise on how a court would necessarily determine how those non-derogation clauses would be different.
Yeah, I'm not asking about the courts. I'm asking about how for example, if a Métis nation in Alberta that is not an authorized Métis nation according to C53, whose rights they are saying is being infringed. And the reason that this clarity has been sought is because that concern is out there.
So I think it's been the position of the department that this bill, without added non-derogation provisions, would not impact the ability of other Métis governments to pursue their own path to self-determination, which we've said. I think it is also our position that, and I think this goes to your question, MP, that the addition of one or both non-derogation provisions would be a means of adding further clarity, that is our intention, that this bill have no adverse impact on any other government, or that it doesn't derogate, more appropriately, that it doesn't derogate from the rights of another Métis collectivity.
Or First Nations in Ontario?
Or First Nations in Ontario.
Okay.
Correct. Is it fair to say, Julia?
Okay, on my speaking list, I have Mr. Carr, Mr. Vidal, Mr. Viersen. So over to you, Mr. Carr.
Thanks, Mr. Chair. I was just going to suggest at this point, I think we've heard department officials reiterate a few times now, I think the legitimate points raised by my colleagues across the way here. As Mr. Batiste mentioned, I think most are willing to support a version of this. Ms. Idlout has put forward a version of this amendment, 4.2, which I think we will find when we get to that part of the process that there is widespread support for. I would like to encourage us to move forward now, as we have a variety of different amendments to discuss. We have heard the points raised. They're legitimate. There seems to be consensus, or by and large support, that further clarity may help to alleviate some feelings and concerns that folks have vis-a-vis other Métis groups not represented by those listed in the schedule. We're there at that point. I'm not sure that it's even necessary based on what the officials have said, but we agree that despite the fact it's not necessary, it has an added layer of protection. We're comfortable moving forward with that. So I would just like to encourage us to move forward to whatever amendment is up next. Thanks.
Okay, next up I have Mr. Vidal and followed by Mr. Viersen.
Thank you, Chair. And sorry, I just on a technical whatever, I want to get some clarity. Ms. Redmond, you were talking about, you're comparing 1.1, 4.2, and then I believe it was NDP 2, which is the same as CPC 1.1, I think, or 2.1. Sorry. Just a minute. I had them all in front of me, and now I shuffled them. 2. Did I get the right numbers there? Are the same, right? And I just want some clarity. In your comments, you talked about CPC 1.1 that refers to Métis people compared to NDP 4.2, it talks about Métis collectivities. And then the other two you talked about being more broader, that would basically encompass the first two. I'm sorry, I don't think I'm being very clear, but I'm trying here. And I think we heard from Mr. Carr that, I mean, or I think it was Mr. Carr that said, what we're looking for, some assurance that, even though you indicate maybe that it's not necessary, some assurance for the people that have expressed the concerns. So in your opinion, if you could just, for my sake, the difference between the clause that talks about Métis collectivities, the one that talks about Métis people, and the one that you called, or that you are referred to as the more broader one. Can you just clarify that for me one more time? I'm sorry, I just want to make sure
Of course.
I'm all the way down this road.
I think it'll be easiest if I start with, well, NDP2 and CPC 1.3, as you've noted, are identical. The phrasing there refers to the rights of the Indigenous peoples of Canada. That is obviously a broad category that covers First Nations, Métis, and Inuit. Métis collective.
And sorry, and that's why we have the following clause that actually defines the Indigenous peoples of Canada, where we don't have it in the other two. Is that correct?
Yes, because my understanding of the intention here is that that's meant to capture all Indigenous peoples of Canada. That's my understanding of what's being proposed. On my reading of the other suggestions, they're a bit narrower in that they refer only to Métis peoples or Métis collectivities, which are one subcategory within Indigenous peoples of Canada. So that's what I mean when one is broader than the other.
Okay, no, I think that's the clarity that I was looking for. Thank you.
Okay, before I go to Mr. Viersen, I just want to check. Madame Gill, did you want to be added to the list? No? Okay. I wasn't sure if you'd raised your hand or not, so okay, thank you. Mr. Viersen, over to you.
Just want to kind of pull apart that Métis peoples versus collectivities. I didn't even notice that in my initial reading of these amendments. Is there like can you explain what a collectivity, like what do they mean by Métis collectivity? Because I actually have a series of amendments to remove that word and say communities, but what does the bill mean by collectivity, and why is that significant, I guess, versus Métis people? Because that's like the major difference between mine and the NDP 4 is that mine says Métis people, which is a smaller group than collectivities. But I guess just can we parse what collectivity is first?
So if I can start here, a collectivity is a term that is generally used when we talk about rights holders in the sense of Section 35. Peoples can sometimes be broader than that depending on the context, but more importantly, collectivities is what is used elsewhere in the bill. So for consistency within the bill, it makes sense to refer to collectivities throughout if we're trying to describe the same concept throughout.
Yeah, well, we're not describing the same concept between Métis peoples and Métis collectives, right? Like that's I guess what's the nuance there?
I think, and I'll obviously give my council an opportunity to add or detract after the fact, but I would submit that Métis peoples is broader, that there are Métis collectivities, and in particular when we're using collectivities, as Ms. Redmond has said, we mean rights-bearing collectivities, that they comprise. There are a number of rights-bearing Métis collectivities that comprise the broader group that you might refer to as Métis peoples, which are one of the 3 Aboriginal peoples of Canada protected under the Constitution. So I think that there are different layers of, I think that there are broader and more specific references within the suggested amendments.
Yeah, because I was imagining more individuals with my amendment, right? Like when I say Métis peoples, I'm not like that was when I sent this into the drafters. That like competing Métis identification, that one individual having Métis identification through the M&A and then through their local settlement or their local Métis of Cadotte is not land-based at all, but it's a local, I guess, collective. It's both broader and narrower in that sense. Is that not correct?
On my read, I think that it would be reasonable to suggest that this bill is very much about the self-determination of specific collectivities and governments that are component part of Métis peoples. I think that some of the other amendments in their language are trying to protect, are through non-derogation, trying to clarify that the rights of other Métis collectivities that have not mandated these governments to represent their rights, that their rights continue to be protected and not impacted by this bill.
Métis collective, like the word collective, that seems like a new word for. Is it been tested in court? Like where did this word come from? Like we have Indian band is like a long-term thing. Is that what we're trying to do with this term, Métis collective? Is we're trying to make that kind of equivalent, or what is the deal? Like where did the term come from, and what do we mean by it?
I think what's important is that this is the way that these Métis groups are describing themselves. They are describing themselves as Métis collectivities. So in our negotiation with them, we respect that, and I think it's in line with the United Nations Declaration on Aboriginal People. Therefore, this is the term that is being used, and I think it's important to respect this word in the context of a bill that is designed to implement their treaties.
Okay.
So it's respecting the way they describe themselves.
I guess just around in that, because I have a whole series of amendments around this as well. Just why was it not in the definitions then? Like, is there a reason why it's specifically not referenced in the what a Métis collective is? Like we have Métis government, I guess that's in there. Yeah. Can you give me some reasoning as to why it's not a definition?
Well, a collective is a very common legal term used to refer to a rights-bearing group in the sense of Section 35 Aboriginal and treaty rights. So this is a term of art. This is a common legal term referring to collectives in this way, whether Métis or other Indigenous peoples.
So it's like there would be court cases and things like that use this terminology that have been ruled on already.
This is not the first time this language would be used.
Okay. Okay. Well, I still think that my amendment is different, is substantively different than NDP 4.2, and I would suggest that we should pass this amendment to ensure that individual Métis people don't have to their concerns around competing Métis identification are alleviated for sure. Thanks, Mr. Chair.
Okay, on my speaking list, I have next Mr. Carr, followed by Mr. Batiste, followed by Ms. Edlut.
Mr. Chair, I just want to again reiterate, I mean, two things. I completely understand where Mr. Viersen is coming from. He wants, Mr. Viersen, you'll correct me if I'm wrong, but you want to ensure, using some form of language, that a group of Métis in Alberta who are not represented by their own view by the MNA would not be left out of the ability, by this bill, would not be excluded from a future agreement with the Government of Canada, I think is what is the crux of what you want. They have told us on several occasions now that even without the wording that we are debating currently, that is clear. So before we even get into the debate in the difference between NDP 4.2 and your CPC, we have already gotten the assurance. So the more time we spend debating the difference in collectivities versus people, which is meant simply to serve as a added layer, then it's just compounding something that we've already received the answer to. So I've just, perhaps I can ask the question of the officials. Mr. Viersen, the name of the specific group in Alberta, I can't remember which you were concerned about, for my benefit. Pardon me?
Métis of Cadot.
The Métis of Cadot.
Yeah.
May I ask the officials, with the current language in the bill, or should we adopt either NDP 4.2 or the CPC motion, would the Métis of Cadot be excluded from the ability to engage with the Government of Canada should this bill pass in future treaty negotiations or self-governing agreements? That group specifically.
My understanding of CERNA's position on this is that it's not necessary to include a provision like this for that option to be available to those other Métis groups.
Okay, but even if either of those two amendments were adopted as an added assurance, I know you're saying it's not necessary, but if they were, either of them, would the Métis of Cadot see a change with a newly amended bill using either clause being proposed affect their ability specifically to engage in future treaty negotiations or self-government agreements with the Government of Canada?
There would be no change. It's our understanding that the proposals may add further clarity or be considered to add further protection, but there would be no change.
Okay, so with that, Mr. Chair, this is now the fourth or fifth time that our officials have reiterated this. I ask that we move on to some of the other amendments that we have before us, because I believe that the assurances, quite rightly, that Mr. Viersen is searching for have been given and will exist with either adaptation of the NDP or his particular amendment. Thank you.
Moving through our list, I have Mr. Batiste next, followed by Ms. Edlut, followed by Mr. Viersen. So, Mr. Batiste.
I'll try to be quick here. I think that we've exhausted that discussion point. I know that there's several amendments here that have, I think, all party support. I almost feel like if we started going through the ones that we all support, that we'd be in a better position to talk about the ones that we don't support because we've taken care of them. I know that might not be the most efficient way of going through, but I see that CPC 1 and NDP 1 are very similar, and that if we pass that non-derogation clause, we could have saved 20 minutes of discussion on this. Just wondering how we can make this an efficient process of going through the things that we do support and then going back to all the things that we might have disagreements with.
To respond to that before I go to my next speaker, there is no efficient way. We need to go through clause by clause. We don't get to leapfrog around the paper. So I have a speaking list. We'll get through the speaking list. We'll vote. When we're done that, we'll go to the next clause, and the next clause, and the next clause. So that's how the process works, and clause by clause. And I'm ready to go to my next speaker, who is Ms. Edlut.
Thank you, Mr. Chair. I'm very much appreciating the line of questioning by the Conservatives, which is rare for me. So, having said that, I am curious about page 11 of the bill, where it talks about, where it's the schedule, where there's column 1 and column 2. And there's slightly different languages in Métis Nation of Ontario and Métis communities represented by the Métis Nation of Ontario. Can you describe the effect of why that difference is there?
The terminology that's used in column 2 of the schedule mirrors the terminology that's used by our partners, the way that they describe themselves internally, the way that they've decided.
By who's your partners? Can you be specific?
Yes, so specifically, our partners, the Métis Nation of Ontario, the Métis Nation of Alberta, and the Métis Nation of Saskatchewan. This terminology is consistent with the way they describe themselves as part of their internal meetings with their peoples, and also it's consistent with the constituting documents they have to establish their government. These terms are also the terms that are used in the agreements which are binding as contracts that were signed in February of this year with the 3 parties.
Okay.
The forward-looking intention is for these terms as well to be defined clearly as part of the treaty. And before we would be in a position to finalize that treaty, we would need to be consulting with any group that had thought we had, for example, established a definition that was too broad. And so, for example, if Cadott Lake was of the view that they were being captured by the Métis Nation within Alberta definition in the treaty negotiations, we would need to consult with them and ensure that we weren't adversely impacting their rights. That is how CERNA arrives at final agreements and final treaties.
So I don't know if this is a direct response to it, but when we read Métis collectivity in the bill, it's because of how it's described in column 2?
In column 2, it's also terminology that's used in the February 2023 agreements, and it's used throughout the bill as the preferred terminology of our partners.
Does that help answer your question? I wish I had a word search thing. If we see the word collectivity in here.
If I could interrupt for a second, I just want to also encourage members. This is really good discussion, and a lot of the discussion is getting ahead to further amendments down the road. But it may help clarify things for them when that point, when we get there. But at this point, we are on conservative CPC 1.1. And I think it's really important, that we get the clarification, but then we, when we are done the conversation, move to a vote so we can get to the next one. And anyway, I just want to make sure that we're, really focusing on this one, and that will be as we move forward, that we stay relevant to the clause that we're on. So I'll just leave that for members to think as we move forward. But the floor is still yours, Ms. Hidley.
Collectivities and peoples, and just to keep on tap what we're meaning, because it could have, I don't know what kind of impacts there will be if we're not consistent, and I'm quite concerned about how that could create confusion, especially given that, for example, we were told by the Métis Settlement Governing Council about their concerns with Métis Nation of Alberta, and how that impact could mean that membership might change from the Métis settlements to the Métis Nation of Alberta because of this enabling legislation. So I'm trying to think of the reality of what's going to happen to the Alberta Métis and what's going to happen with each of their membership based on what happens on C-53.
Yeah, no, and please continue, get the clarification you need, but I'm just as a general reminder that if, where as much as possible, focus on what we're at, but the floor is yours, so please carry on, Ms. Idlut.
Well, I was asking about making sure that when we do talk about collectivities and peoples, that whatever the impact of that interpretation is going to be, like it needs to be made clear to us so that when we go back to our constituents or people that we've been consulting with, that indeed, if there is a potential for rights to be infringed, the duty to consult is going to be triggered right away. And that at this point, that trigger has not been reached. That's why there's not been that duty to consult for those other groups, is my understanding.
It's correct that it is our position that the agreements that were signed in February of this year, insofar as they are contracts that are binding on the signatory parties, that those contracts did not trigger the duty to consult. Similarly, this legislation, the treaties, we will have a requirement to consult on the treaties.
Thank you.
Okay, Mr. Vierson, you're next on my list, followed by Mr. Vidal.
Yeah, just going back to Mr. Carr's comments a little bit, like the challenge that this bill and that I'm trying to get at with my amendment, and we may need to amend it, is just around competing Métis identification, and the point being is can a Métis person be a member of the MNA and Peavine Métis settlement, MNA and Métis of Cadott? That was their concern around. Were they going to be competing Métis memberships? Are these going to be competing? Will the MNA be competing for their members? And I'm not even necessarily certain that this is when I sent. I quoted it and I sent that in saying, hey, we want to make sure that we're not setting up competing memberships. And what would happen if somebody is a member of both? What does that look like? And I guess maybe we can ask our officials about that as well. If a person, right, a Métis person, was a member of the Peavine Métis settlement and a member of the Métis Nation of Alberta, there was some concerns around these competitions. Now, I imagine that there wouldn't necessarily be a challenge for that, but there's nothing in this bill that prevents that from being a thing.
So under the 2020, the agreement signed in February of this year with MNO, MNA, and MNS, it is explicit that there is not an ability while it is the right of a Métis individual to choose their government, and so long as they meet the eligibility criteria and so on and so forth, they're able to choose which government is to represent them. There's a requirement that there be no dual citizenship, so those individuals need to choose one government. They're not able to choose the MNA and Cadott as an example. However, the one exception is the Métis settlements. There's a provision in the MNA agreement signed in February of this year that provides for dual citizenship to both the Métis settlements and the MNA. The reason for that is the status quo as it exists today, and it was a part of the decision of the government to maintain that status quo and to do so explicitly. I do understand, I can't recall whether or not it was raised directly by President Lamouche as part of the testimony, but I want to be clear, we do understand that the Métis settlements have raised some concerns about that approach, and for that reason, it'll be something we need to revisit in terms of the text as part of finalizing a treaty, because again, we have an obligation, constitutional obligation, to ensure we're not adversely impacting the rights of other governments that are not signatories to those future self-government treaties.
But you can see where the communities would be concerned that, I hate to use the term, but like a poaching of members. Essentially, that's these other communities maybe have existed for a long time, and now suddenly there's a new treaty, a new agreement, and a desire for to switch your allegiance essentially. Can we protect it for that in this amendment?
I understand the non-derogation proposals to be protecting the rights of other collectivities. I believe, and I would submit, that the agreements, the legislation, and the future core governance treaties all are enshrining as a principle the right of Métis individuals to choose who properly represents them, so long as they meet the PALI. I don't want to belabor the point, but it is our position that the right of these individuals to choose their governments is protected within those parameters. Beyond that, I don't have much to offer, Mr. Viersen.
Okay. I guess it just getting back to this, how do we, I'm still not, your comments again don't align or don't clarify for me whether we should be using Métis peoples or Métis collectives in that, and that's the crux of whether we go with NDP 4 or with this one, is around, right? Because you use them kind of somewhat interchangeably, but they come at it from the opposite end of the problem essentially, which still doesn't solve my problem.
If I understand correctly, I mean, your intention sounds to be to have one refer to individuals and one refer to, or the other referring to groups, at least as they're drafted.
Yeah.
The reference to Métis peoples and Métis collectivities, I think, can be read in a very similar way as both referring to groups.
Okay. That was not my intention with this amendment. So how would we improve it to the self-determination of Métis individuals? Would that be a better term to use? You're not going to commit to that one, eh?
It's not for me to draft for the committee.
Yeah. Because I looked to Jaime a little bit on this. Like, if we amended mine to Métis individuals, would that, like, because I don't think we capture the same things between the two, and I'd be open to a friendly amendment on it that would say self-determination of Métis individuals to protect.
More questions. You'll get there.
What's that?
I said, ask some more questions. You're getting there. You're almost there.
Well, I want you to support my amendment. Because I don't think that they're the same.
I'm going to jump in here for a second, just to be clear on procedure. You're not allowed to amend your own amendment, so you can't offer a sub-amendment. And so, colleagues, what I'm going to do is...
That's why I was asking for a friendly amendment.
Suggest that we actually pause for like 3 minutes so that each of the sides... We've had some really good discussion here, but I think it may be worthwhile for each of the groups to reflect on where you want to go with this. And then I'll come back with the same speaking order with Mr. Viersen. I have Mr. Vidal and Mr. McLeod on the list, but I'm going to suggest... Okay, we'll go to our witness, Mr. Shintz, first. Okay.
I just want to offer the point before the further contemplation of this during the break that we don't typically refer to self-determination on an individual level. We don't tend to refer to the right of individuals to self-determination as part of implementing bills, and it's a collective right.
Yeah, just wait. I do have Mr. McLeod. Yeah, I have Mr. McLeod. Sorry, I am going to pause us here, though, just if everybody can put their heads together for a second. We'll come back in 3 minutes with Mr. Viersen still having the floor, and then Mr. Vidal and Mr. McLeod is my speaking order. So,
self-determination word for collectives is usually, sorry, we're having a side conversation.
yeah, so let's suspend. You guys can have the discussion briefly. We'll come back in 3 minutes. So for now, we're suspended. That's a little bit longer than 3 minutes, so happy to carry on. So, Mr. Viersen, Mr. Viersen, you had the floor, so we'll see where you're at. And then on my speaking list, I have Mr. Vidal and Mr. McLeod. So that's the order we have.
Rest it up here, Mr. I'm playing shorthanded here. It looks like. Yeah, I guess the Ms. Itloud and I had quite a conversation here. Again, it goes back to, and I suppose I'd continue to ask for the friendly amendment to perhaps change it to individuals, from the word peoples to individuals. But there is a challenge around how do individual Métis play through this whole process, and so I'd like this bill to recognize that, and I think that my amendment pursues that ideal somewhat. So I'll leave my comments there for now, Mr. Speaker.
Okay, thank you, Mr. Viersen. We'll go to Mr. Vidal, and then Mr. McLeod.
Sorry, Mr. Chair, but my stomach all of a sudden decided I need to be out for a second.
Welcome back.
Thank you. Sorry, just Ms. Redmond, earlier you in your answer to Mr. Carr, I'm not sure you were unequivocal, so to speak. You said it is the opinion of CERN, I believe, or it's the position of CERN, if I'm not mistaken. So just, again, to flesh this out a little bit further, maybe one of the concerns we heard in the committee testimony, and I'm referring back to Alberta specifically here, was some concerns around the constitution of the MNA and how it dealt with their membership, and some of the concerns of some of the communities that Mr. Viersen is talking about. A little bit after that, Mr. Shintz, you talked about the status quo being the Métis settlements being, I don't know if accepted is the right word, but very clearly separated out from inclusion in this. So what assurance is there to the other folks in these other communities? You said it's already in the bill, it's already there, but yet we specifically reference in the bill the exclusion, or maybe it was in the agreements, not the bill. Sorry, it might have been in the February 23 agreements. You talk about the Métis settlements being specifically excluded from this. These other communities, what assurance do they have that they're not going to somehow get swallowed up in this by either the existing constitution of the MNA or some future change to that constitution? Like, do we not need something like this for them to have that assurance then? Or am I hope I'm making my point.
I think so, Mr. Vidal. I'll try to respond. And there were a few pieces to that. I'll start with the Constitution. The self-government treaty, while final treaties or self-government treaties that CERNA negotiates with Indigenous partners require that there be a constitution in place, we do not give legal force and effect to those constitutions. Those constitutions are documents that are used for the internal governance of the MNA and the MNA's collectivity. You asked a question as well. I think you were asking for some clarification around my earlier comments about the settlements to try to give some added clarity. What we say in the 2023 agreement signed with MNA is that their laws regarding citizenship will not allow an individual who's eligible for citizenship but is enrolled on either the Indian register or another banned list or enrolled as a member of another Métis government, that they would not be provided citizenship. There's no dual citizenship. However, we say in the immediate next clause, which is 8.08, that nothing in this agreement prevents a member of a Métis settlement from registering or being a citizen of the MNA. Again, that is the status quo as we understand it as it exists today. In terms of providing added protection or clarity that those who've made clear to this committee that their rights are not being represented by the MNA, I think that that is the intention of this committee in bringing forward non-derogation language. I believe we've made our points with respect to that.
So selecting one of these various clauses, you believe would give assurance to those folks that maybe is not in the existing legislation?
I think that that's fair to say.
Yeah, thank you. Okay.
Okay, Mr. McLeod, you're next on my list.
Yeah, I just wanted to point out or speak to the comment that Mr. Viersen raised about membership in different Métis governments. And I think it was very clear that from the witnesses that presented to us that it's up to them to decide who their membership is. And as a Métis person, you know, I've had the opportunity to join different Métis governments. I think the concern is that we'll have people that are registered with one government and also registered with another and get services and benefits from both. I believe that, and maybe the officials could speak to this, that there's a real clear procedure to follow. The enrollment with family trees, everything else has to be provided. So the government knows exactly who the members are, and you cannot be a beneficiary of two settlements or two treaties. And maybe the officials could speak to that. Once you register and you're signed up with one government, you can't go join another one and get the same kind of treatment, benefits, whether it's services or a financial benefit, whatever the case may be.
We specify in the 2023 agreement, and I just want to say that the treaties are going to be based on those 2023 agreements, and those 2023 agreements provide parameters for those treaty negotiations. We specify that Métis government laws in the area of citizenship cannot provide for an individual who's eligible to be enrolled as a citizen so long as they are on the list of another Indigenous government that either has a concluded self-government agreement that is either protected by the Constitution or one which is not protected by the Constitution, so standalone self-government. So it is a parameter placed on the lawmaking jurisdiction.
Thank you, Chair. Based on what we've been hearing today, I'd like to, and I can probably take some time to write this if need be. I'd like to propose an amendment to Mr. Viersen's amendment, or, what's that? Sub-amendment, sorry, that's what I meant, sorry. Yes, thank you, Chair. See, that's why you're in the chair. I appreciate that, you're a helper. Can we change the word Métis peoples to Métis individuals?
I would word it in the form of a statement, not a question. We're not in jeopardy. So give me a sub-amendment to deal with, and we will.
So, okay, so we're in the process of writing that up right now? Okay. Be amended, was the CPC 1.1? Remove the word Métis peoples and replace with Métis individuals. Yeah, we're just going to send it in writing here. Should be coming momentarily. Okay, should be sent, I think. Changing CPC 1. Yeah, I think, well, quickly while we're waiting for the email to arrive here, I think this addresses, or at least somewhat addresses, or aims to address some of the concerns that Mr. Viersen is hearing in his riding, specifically because he has a number of settlements in his constituency, and I think from what we've been told, he's been hearing from the people in his area that there is, I guess, some interest in having the individual Métis recognized as opposed to a collective, because everyone is an independent thinker, an independent individual that can have the ability, or should have the ability, I guess, to choose who is representing them. And if we have an individual that wants to be part of a settlement, or maybe not at all, they would have that ability to still access the same standards as those belonging to, in this case, the M&A. And hopefully that addresses the concerns that Mr. Viersen is talking about, and allows us to keep moving along here. But I think at the end of the day, we're really trying to find a path forward and address the concerns that we're hearing on the ground, because I think it's important that we get this right. And I know that the email should be coming. Oh, you got it. Oh, perfect. Okay, then I can stop talking.
She needs to send it to
Oh,
us.
okay. We're sending it, so I can keep talking, I guess.
Could I ask a question while we're waiting for the thingy? Because I would love to know from the legal counsel what the legal impact of that change would look like.
On pause right now. Hang on.
Mr. Chair, do we have a speaking list?
I'm sorry, I'm just getting a technical clarification on something before I go to you, Lori. Just one sec. Lori, did you want on the list? Because I have Mr. McLeod, Mr. Viersen, and then you on the list. If you can wait, so let's go, Mr. McLeod. Okay.
Thank you, Mr. Chair. And I think Lori was raising concern or a question along the same lines as I am. As Indigenous people, I know First Nations and the Métis government that I belong to, we tend to think as collective versus individual, and we've lived our lives that way. Our culture is based on that, and I'm really nervous what this means when we start moving away from the collective approach to talking about individual Métis individuals versus what the agreement's about. So I just needed a lawyer sitting beside me here to interpret what's being discussed, but I would have to ask what that means, how much of a change that is.
You're posing the question. Please pose the question to our officials. So if someone wants to respond to the member's question, or if you need it reframed, I can get it.
I'll take my cue.
Thank you.
The right to self-determination and the inherent right of self-government are rights that are described normally as collective rights. So to make reference to individuals in the context of rights that are collective rights would be a bit unusual. So it would make more sense to refer to a collective when talking about collective rights, which self-determination and self-government are.
Okay, Mr. McLeod, after you, I have Mr. Viersen.
Thank you, Mr. Chair. I just, I guess getting back to just around, say, for example, harvesting rights. Currently, Métis have harvesting rights as individuals. I assume, like there's, like, how is that organized at this point? I guess could you explain that for me?
I mean, without getting too far into a discussion on Aboriginal rights today, there are rights that are held collectively and can be exercised by individuals. Something like, rights related to self-government, such as elections, are collectively held rights. They go to the right of a community to organize themselves. But obviously some component of that has an individual exercise. An individual citizen voting for the leader of their collective, their government, for example. So harvesting rights would be one example of that. They're a collectively held right that can be exercised by an individual. It depends on the context.
Yeah, so currently, Mr. McLeod is exercising his harvesting rights. If he chooses not to, hypothetically chooses not to join the M&A in Alberta, would he continue to be able to exercise those rights without being a member of the M&A?
I mean, this is something that's sort of outside the scope of, the treaties we're discussing right now. I mean, harvesting isn't before us, so a jurisdiction like that would, it would depend on the terms of the treaty, how that right might be exercised.
Yeah, I guess, but the challenge that we're going to run into is after this bill passes, we will have defined Métis governance, of which then Métis identification is going to come through those governments. Folks that identify as Métis but choose not to join the M&A, will they continue to have their, because I don't quite understand how the harvesting rights currently is kind of organized. So would they continue to have harvesting rights if they choose not to join the M&A? Does that make sense?
So the first part of your question, Mr. Viersen, I seem to suggest that this bill was establishing something other than what it establishes. What it recognizes is that the M&A, the MNO, and the MNS are Indigenous governments, that they've been mandated to advance the collective Section 35 rights of their collectivities, and it provides a legislative framework in which to give legal force and effect to future treaties that will cover their right to govern themselves and organize themselves internally. It does not establish parameters for Métis identity in the way that I understood the beginning of your question to suggest. And I agree with Ms. Redmond that we're not here today to speak as experts on Métis harvesting regimes. This bill doesn't touch on that.
That's what the amendment is trying to get at, is around, nothing in this, that's what we're trying to clarify around, is this, the individual rights to harvest, for example, that won't be derogated by this bill. That's specifically what this amendment is trying to get to, and that's why I've moved it moved it to individuals rather than peoples.
I understand the Pally decision to say that the rights that individuals exercise are derived from the historic collectivity that they were a part of as Métis people prior to effective control. Mm-hmm. I think the rest of the answer goes to what Ms. Redmond has already stated about individuals being able to exercise certain collective rights. I think that the non-derogation language, and there are several examples in front of us, all offer a variation on of added protection or added clarification that there will be no derogation of others' rights. I think individuals are captured insofar as their rights are inherently collective. That's what I understand the courts to have set out.
Yeah, but prior to having a codified government, right? Like that once this bill passes, suddenly we have codified governments that we didn't have, unless I'm mistaken, that we didn't have prior to the...
We've recognized as part of the 2023 agreements that these are Indigenous governments and that they are functioning as governments and that they are exercising lawmaking authority. I think the distinction that you're touching upon is the difference between an asserted right and a right recognized under an agreement or a treaty that is given the force of law.
Okay. I hope that I hope, Jaime, you're coming to my logic here, and we'll get your support here shortly.
Next is Ms. Idlut. When you're ready, Lori, the floor is yours.
Thank you. So just to repeat my question that I don't think I was heard. If Mr. Vierson's recommendation to allow the interpretation of Métis individuals asserting those types of things, what can the potential legal impacts be? So for me, when I look at C-53, I see it as good protection against identity theft. We know that there's a lot of pretendians out there, and because of our status, because of our beneficiary list, because of the registries, we're able to confirm through our collectives, through our governments, who Indigenous peoples are. And I wonder if opening that interpretation creates a loophole for those people that might not be Indigenous to try and assert indigeneity because of if that were to be allowed to happen in this legislation. I don't know if I'm interpreting it correctly, but is that a possibility that would happen?
I think I can at least give a partial answer to your question. And to reiterate what I said before, the right to self-determination and the inherent right of self-government are collective rights. It would be unusual and a departure from how these rights are referred to in other statutes and in other treaties and agreements for those rights to be referred to as relating to individuals, despite the exceptions, of course, where certain collective rights can be exercised have a component of individual exercise. So it's not really clear how that would be interpreted, because that would be as I understand it, on my understanding of it today, a novel way to describe that in law.
So keeping it as collective rights, because that's how colonial governments have learned to recognize Indigenous peoples' worldview as always taking care of each other, whether it's through harvesting rights, is that acknowledgement. I don't know that we need a whole history given to us about how we came to ensuring collective rights when it comes to Indigenous peoples. But I think that what I'm saying with this committee is that we need to be very careful when we're considering this, because of the worldview that Indigenous peoples, as Michael McLeod was saying earlier, First Nations, Métis, Inuit, before colonialism. That is why we've always talked about collectives. That is why we've always talked about families. And when we talk about a family, we're not just talking about a nuclear family. We're talking about extended family of our grandparents, of our aunts and uncles. And because of that, these can actually be seen as protecting that sense of nation within those Indigenous families. I know it's a difficult question, but I understand what he's trying to do, but I think that we need to be very careful, and I know that you're being bureaucratic when you say that this is unusual, because to me, it's not just unusual. It's the potential for Pandora's box opening is a sincere concern that I know that Michael has shared briefly in his testimony, and we need to be careful. We need to make sure that we don't do it just because it's not unusual.
Yeah, I mean, I appreciate what you're saying, and I don't think I can say more beyond collective rights, apply to a collective, and for that reason alone, aside from perhaps others that you've raised, I leave those to you, but it makes sense for collective rights to refer to a collective.
Mm-hmm. Okay, thank you.
Okay, Mr. Carr, the floor is yours.
Mr. Chair, I would like to refer back to something I've raised now for what will be the third time. Mr. Viersen, I believe you were here for the duration of a very long set of testimony that we have all been a part of over the course of this study. These questions have been dealt with time and time again. I'm starting to question the legitimacy, perhaps, or the root cause of where some of these questions are coming from, as I'm having a difficult time understanding what's missing from the clarification that's needed vis-a-vis the amendment that you've put forward. Is there anything, I ask our officials, that has changed since I last intervened vis-a-vis what you have heard, including what you've spoken to in regards to the sub-amendment, that would lead you to believe that the group that Mr. Viersen, rightly so, has raised concerns in search of reassurances for, vis-a-vis a group in his home province, that that group would not in any way, shape, or form lose out on the ability in the future to enter into a self-governing agreement or a treaty agreement with the government of Canada by virtue of the language that's been put forward in these amendments?
No. The only thing that has changed is that we've raised our concerns with the sub-amendment. So nothing has changed from the last time that we had answered the question, Mr. Carr.
Okay.
Mr. Viersen, are you done?
No, I'm not done quite yet. Mr. Chair, what time do we have till? 5:30. 5:30, okay. Is there any language that you think could be added that would provide the type of assurance that Mr. Viersen or others are seeking at the moment?
I think that the other non-derogation proposals that have been put forward offer different versions of what I understand to be a similar, if slightly different, wanting to be fair to Mr. Viersen in terms of text, but they offer the kinds of protection that I understand the committee to be looking for.
Can I ask if the department has had any conversations directly with any of these communities throughout the course of this study to answer any of the concerns that they may have raised? Whether that be the same concerns raised by Mr. Viersen specific to this community in his home province or any others?
I've had discussions with a number of the communities that have appeared before this committee, but not since the study has began, on the basis of the agreement and the legislation that's now before us, but not, to your question, not since this study has began, Mr. Carr.
Okay. Can I ask that same question to other officials present?
Nothing to add.
And is there any, oh, sorry, John. Okay. Sorry?
I assumed incorrectly that you were done.
Oh, no, I'm not done. Do you believe that there is any other area currently in the wording of the legislation, whether pertaining to the amendments put forth by Mr. Viersen and Madame Idlud, that would in any way, shape, or form take away from the right of any government, Métis government, not mentioned currently in the bill, should this bill pass in its current form. So are there any other areas of the legislation not specific to the amendments they put forward that concern you vis-a-vis that?
I'm not certain I followed the question, Mr.
Sure.
Carr, but I believe.
I'll rephrase it. My apologies. The amendments that my colleagues have put forward are specifically in relation to all of the things that we've been talking about specific to these groups. Those amendments aside, what they're trying to deal with, are there any other areas of the legislation, aside from those that they are seeking to amend, that you feel merit our attention in regards to a potential threat to the pre-existing or future rights of Métis governments or any Indigenous governments?
No. Absent these amendments, absent even the amendments before us, we have an obligation to ensure that we don't adversely impact the rights of other Métis communities, other First Nations communities and collectivities.
Okay. Ms. Redmond, can I ask you to respond to that as well, please?
I have nothing further to add.
Okay. Mr. Ryder?
Same. Nothing in this bill would have impact on the rights of other groups in and of itself.
I would just add, in fact, we're trying to recognize the rights of the partners who've helped us co-develop this legislation.
Can I ask you in that same line of questioning then, should this legislation not pass, what future impact do you foresee that having on these Métis governments in question?
I don't know that it's for me to say what the impact is for the Métis governments. I think they've tried to answer that question a number of times in providing testimony to this committee. I can speak to the practical fact, if that's helpful, Mr. Carr, which would be that we would not have legislation which we are seeking to ultimately be given royal assent, which would exist for us to give effect to future self-government treaties, to recognize the self-government rights of our partners who were recognized in the Constitution Act in 1982 and who still do not have recognition in federal law.
I asked that question of the others as well, if they have anything to add.
The only thing I would add is that those agreements signed in February 2023 between Canada and each MNA, MNS, and MNO would remain in force regardless of whether C-53 becomes law.
Okay.
I have nothing to add.
Okay. Good, Mr. Chair.
Okay, next is Mr. Vierson.
Well, Mr. Carr is concerned about my motivation for this. So we have, the Library of Parliament has put together kind of a list of recommendations, and the recommendations that this bill be withdrawn is from a host of folks has been put forward, and they all have issues with the bill, and my amendments are in response to that, to try to make sure that we can get some of these things fixed that folks came here to be, that they had like grave concerns with this bill. One of those concerns was around competition between Métis organizations, Métis groups for Métis identification. Now, I would still say that my amendment and the subsequent sub-amendment is trying to tackle that issue around a Métis person that does not find that there is a Métis government that represents them. They do not want to join. How do we ensure that they don't lose their Métis identity and Métis? Yes, but that they said that is not the case. But I'd still say for the clarification of those individuals, I think we need to pass an amendment that definitely makes that codified in the bill, and that is no, because Laurie's is about Métis collectives, which we
Which
had a
they've
long
told us.
conversation.
Colleagues, I'm just going to jump in here for a second.
Yeah.
We have reached 5:30, and I've been advised that there's been a deal reached by the whips that we will end at 5:30 today. So I'm going to keep the speaking order that I have, with the floor being Mr. Vierson's, but for now, folks, we're adjourned.